during the event. So please check your email and stay tuned for those. And so I'm going to turn it on over to Alexa to introduce Professor Blackman.
Hi, everyone. So I have the privilege of introducing Professor Blackman. Josh Blackman is a professor of law at South Texas College of Law in Houston and an adjunct scholar at the Cato Institute. Professor Blackman's authorship on constitutional law issues spans approximately 64 published articles, 15 judicial citations, and several casebooks and supplements. His latest book is entitled An Introduction to Constitutional Law. Professor Blackman is a frequent guest on network television, including ABC, BBC, CBS, Fox, and NBC. He has published commentaries in the New York Times, Wall Street Journal, Washington Post, and other leading national publications. And finally, he's the president of the Harlan Institute and the founder of Fantasy SCOTUS, the internet's premier Supreme Court fantasy league. And it goes without saying that we are thrilled to hear him speak tonight. Thank you.
Thank you so much. It's a real treat to be here. I actually started my teaching career at Penn State. Well, I went to Penn State for college, and then after law school, I clerked in the Western District of Pennsylvania in Johnstown for Judge Kim Gibson. And my very first teaching job was actually at the Penn State Law School. At the time, we were merged with the State College campus. It was one entity. And I would teach a class on both campuses, and it's something I very much enjoyed. So my love for teaching was very much born at Penn State. So it's really, it's good to be here. In fact, it's my first time speaking at Penn State Law throughout all these years. It's just never happened. So I thank to Oliver and to Alexa for having me out here. The topic today is the Second Amendment outside the home. And it's a very well-timed topic. Next Wednesday, the Supreme Court will hear argument in a case called New York State Rifle and Pistol versus Bruen, which presents the question of whether the Second Amendment protects the right to bear arms outside the home. So what I'd like to do today is give you a brief overview of Second Amendment case law and bring you up to the present. We start our story in 2008 with a case called DC versus Heller. This case found that DC's handgun ban was unconstitutional. The Supreme Court held that the Second Amendment guarantees an individual right to keep and bear arms that's not connected to malicious service. But the court stressed that the Second Amendment is not unlimited. It's not a right to keep and carry any weapon in any manner for any purposes whatsoever. The exact scope of the Second Amendment, however, has been subject to dispute for more than a decade. Heller did not resolve the question of whether the Second Amendment governs outside the home. There are hints in Heller. For example, the word bear means to carry. So one might think that the right to bear arms means the right to carry arms outside the home. But the court also said that they were not casting doubt on long-standing prohibitions, such as laws forbidding the carrying of firearms in sensitive places like schools and government buildings. So the fact that the court referenced carry and said, well, you're allowed to ban it here, suggests that you can't ban it somewhere else, right? So that the language in Heller seems to suggest that there is some right to carry outside the home. 2 years after Heller, the court decided McDonald v. City of Chicago. This is a follow-up case to Heller. McDonald held that the Second Amendment was incorporated. That is, the right to bear arms limited not only the federal government, but also the state government. McDonald didn't say much more about the Second Amendment. All it said was whatever the right means against the federal government, it means the same against the state government. Now, McDonald was 2010. And since 2010, the Supreme Court has not decided any major Second Amendment case. The closest we get is a case called Caetano, Caetano, Caetano versus Massachusetts from 2016. The state of Massachusetts banned stun guns. They sort of these electric zapping guns. They don't fire anything, but they sort of just zap you. And the Massachusetts court held that the stun guns were not protected by the Second Amendment. Why? Well, because stun guns didn't exist in 1791, so you can't have any new weapon. And that's not what Heller said. Heller said we look to the types of weapons that would have been in common use by people in that time period. So the Supreme Court reversed in Saitano and said, well, no, you applied the wrong standard. But that was it. And the court has not decided any Second Amendment case since McDonald. So there are a couple of questions to think about with the Second Amendment, right? So first off, who bears the burden, right? When you're trying to challenge a law in court, who has the burden? Is it the citizen challenging the law? Or is it the government official who has to defend their law? And I'll give you a preview. I'm sure Gilbert would agree. When you're suing the government and you have the burden, you're probably going to lose. And when you're suing the government and the burden's on the government's probably going to lose. So usually in common law, whoever has the burden loses. Why? Because it's hard to make your argument. It's a lot easier to say, well, we don't have to defend our law. You have to show us why our law is irrational. Heller seems to suggest that the government bears the burden to defend their laws, but the lower courts have really been all over the place. So in the wake of Heller, there's a massive disagreement over how to review. So I'll just give you some overviews. The Second Circuit applies some form of nominal intermediate scrutiny and places the burden on the challenger, the citizen. So it's very hard to win. The First, the Third, where you guys are, and the Fourth Circuit is very similar. It involves deference to the legislature, where the courts apply a presumption of constitutionality. The Seventh Circuit has a different standard. It puts the burden on the government, and it applies heightened scrutiny that looks to history. The Ninth Circuit has a two-step framework, but it's not really two steps. Whatever interest the government puts forward is good enough, and the court says this is going to be presumptively lawful. Call it intermediate scrutiny, whatever it is, but it's very deferential. The DC Circuit has one of the stronger tests. Was written by Judge Kavanaugh when he was a circuit court judge, and he said that we look to history. Only a couple courts have held that the Second Amendment governs inside the home. The Seventh Circuit case of Moore versus Madigan from 2013. The court said that Illinois cannot ban carry. But that same court did uphold strict licensing requirements for carry. Another case, Wren versus DC, said that you have the right to carry in the District of Columbia. DC did not appeal that case to the Supreme Court because they would have lost. So that's only a circuit court case. By contrast, the Second Circuit held that there's really no right to carry outside the home. The government can deny it for any reason, just about whatsoever. Other circuits, the Ninth Circuit said there's no right to carry at all. Maybe the right to open carry, but we won't decide that at all. If you see what I'm getting at, the courts are kind of all over the place on the Second Amendment, but generally gun rights lose in every single case. Now, between 2010 and 2020, there was really no Supreme Court case involving guns. But finally, in 2020, the Supreme Court granted a case, New York State Rifle and Pistol Association versus New York City. This was a challenge to New York's strange law on concealed carry. It wasn't even a right to carry a gun in your home. On your holster. Instead, New York required you to have a permit to transport a gun from one house to another. And the gun had to be transported in a locked box in your trunk. Good luck if you have to take a subway, right? So it's a very weird law. So the court grants certiorari, and then something very strange happens. New York repeals the law. Almost immediately after the Supreme Court grants the case, New York repeals its law. They were trying to moot the case, that is, make it impossible for the court to decide it. Not only did they repeal the law, the state enacted a law that made it impossible for New York City to reenact the law. So look, this controversy, in my mind, was completely moot. And the Supreme Court punted it. And they said, okay, we don't have to decide. This case is moot. There were a couple of dissents from Justices Alito, Thomas, and Gorsuch saying this is an obvious effort to frustrate the court's jurisdiction. The court should not give a sanction to these sorts of chicanery. We would decide the question and rule for the Second Amendment. Justice Kavanaugh wrote a concurrence. He said, well, I agree this case is moot, but let's take another case, right? At the time, there were nearly, I think, a dozen cases on the docket that presented Second Amendment cases. And Kavanaugh said, let's take another case later. What happened? 6 weeks later, the court denied cert in all of those gun cases. This was a sad day. I called it Blue June or Blue Monday first, but it was a very sad day for the court. They turned away all the gun cases. The court decided Bostock. There's a lot of bad things that happened that day. The rumors from various reporters is that Chief Justice Roberts signaled that if they granted a case, he would rule against the Second Amendment. So to avoid a defeat in front of the Chief Justice, the court simply let the cases go. But then the court changed. Justice Ruth Bader Ginsburg passed away, and Justice Amy Coney Barrett replaced her. And with that, Chief Justice Roberts was no longer the fifth vote. And after some listing and relisting, the court finally granted certiorari in the latest case, New York State Rifle and Pistol versus Bruen, B-R-U-E-N, not like the UCLA logo. This is B-R-U-E-N. And this will be argued on Wednesday, November 3rd, so just a week away. This case is about the right to concealed carry. In New York City, carrying a handgun outside the home is prohibited without a license. But you only get a license if you have what's called, quote, proper cause. Proper cause. What does proper cause mean? You must have an individualized special need. Merely wanting to defend yourself is not enough. You have to have something really special. What does that mean? You have to be a celebrity, maybe friends with the sheriff, maybe go target shooting with Alec Baldwin, right? There are different things. You have to be someone special, right? You have to be special. Regular schmoes like you and me are not getting a concealed carry permit in New York. We laughed away. So really, it's an absolute discretion, absolute power to deny people the right to bear arms outside the home. Now, New York has not repealed this law like they did last time. Instead, they've defended it. And they've argued that they can deny it at will. This case was brought by a couple plaintiffs, and they say they want the permit for self-defense reasons, right? They argue that New York City is not a safe place. It's not. And they want to be able to have this weapon to defend themselves. New York said, sorry, your reason's not good enough. Go away. And so they lost their case. Under circuit precedent in the Second Circuit, the right to bear arms is, so to speak, outside of the core. It's not the core of the Second Amendment because Heller only concerned home self-defense. This is a straight-up challenge saying that the circuit precedent is wrong. This case will be argued on Wednesday, and let me give you now a preview of some of the arguments that I think will be made there. Okay. The petitioners, that is the challengers, argue that the Second Amendment enshrines a pre-existing right. And this right stretches back to the English Bill of Rights in 1689. So it's a very deeply rooted right. And this right is tethered to self-preservation, which happens either in your home or when you are on the road to kill. During the founding era, carry was very widespread. Who carried a gun outside the home? Washington, Jefferson, Adams, James Wilson, and others. And there was a lot of history of fairly prominent people carrying guns outside the home. In 1822, there's a decision by the Kentucky Supreme Court that struck down a law banning concealed weapons. But you could still carry openly. In fact, for much of American history, you didn't conceal carry. That was considered dishonorable. Open carry was the way to go. After the Civil War, though, many restrictions were put on carrying. But these laws weren't enforced equally. In fact, they're primarily enforced against free black citizens and barring them from self-defense. So a lot of the gun control laws, which advocates sort of cite, have very, shall we say, shameful origins as Jim Crow measures. Indeed, after the Civil War, Congress enacts the Freedmen's Bureau Act. This law said that the right to bear arms was a fundamental right and must be enjoyed by all people regardless of race, color, or condition of servitude. And in 1871, Congress enacts the KKK Act, the Ku Klux Klan Act. And its drafters explained that a law was a means to enforce the right to keep and bear arms in public. So there's a fairly detailed history of why this right to bear arms is so deeply rooted in our history. There's also some shameful history on behalf of New York. The New York gun law was actually enacted in 1911. It's called the Sullivan Law. And the purpose was to deny foreign-born people the right to bear arms, sensing a pattern. There was a story in the New York Times that said in the first 3 years of the Sullivan Law, 70% of the people who were arrested had Italian surnames. This was a law really meant to target immigrants. And this law exists to this day. As far as the text goes, the phrase bear and keep are two distinct rights, and we have to keep these rights separate. Keep arms is a way to possess an arm, and bear arms meant to carry. So these were distinct terms. And even the 1689 English Bill of Rights meant the right to carry a gun outside the home. Okay. Now, the arguments on the other side, I always try to be fair, contends that there's actually a long history of gun control laws. And it was actually fairly common in the Wild West to impose restrictions on carrying in certain places at certain times. And those very well may be fair historical examples. But New York isn't simply regulating when and where you can carry, it's complete prohibition. And some with absolute discretion, right? Anytime, any place, they can tell you to stop it. So I think the New York law is on shaky ground. Now, what's the court going to do here? Whenever a case involves something like a guns or abortion, the usual rules don't seem to apply. The Heller case from 2008 was a victory, to be sure, for gun right advocates, but included a lot of language that said we have to uphold longstanding prohibitions and we don't want to rock the apple cart. So I don't know that this is a surefire win. I think New York probably loses here, but it's not guaranteed. And even if New York loses here, people in New York will not be able to carry very often. I think virtually every place in New York will say no carry allowed. So it'll be even very difficult to walk from block to block without running to a no carry zone. All right. Let me stop here, turn over to Gilbert for a few moments, and I'm happy to take your questions later. So thank you all so much for your attention.
Thank you. Before, I was going to introduce you. Go ahead. There you go. Okay. So Gilbert Ambler, as some of you possibly may know, is a criminal defense attorney specializing in firearms law and is licensed to practice in both Pennsylvania and Virginia, where the bulk of his practice implicates constitutional issues. As an independent program attorney for U.S. Law Shield, Attorney Ambler has extensive experience advising and representing clients in both self-defense incidents and other firearm-related matters. He's also an expert on constitutional rights restorations, civil rights restorations, and regulatory compliance for federal firearms licensees. He's the co-author of the Ultimate FFL Resource Guide. And finally, Gilbert owns a highly rated law firm that serves clients primarily in the areas of criminal and family law, to top it all off, he's a 2018 graduate of our very own Dickinson
Woo!
Law, and so we're very grateful for him to be here and to comment during this event. The floor is yours.
Thank you for the kind words, Oliver, and thank you, Professor Blackman. I appreciate all of the commentary that you've provided so far on this subject. I think that the word of caution that you left off with at the end, which was this is probably a loss for New York, but not a surefire thing, is something that would be good for the entire Second Amendment community to remember right now. And that's not just to say a win or a loss is going to go one way or the other, but more to imagine what a win or what a loss might look like. And I join, I think, most firearm advocates where I say, I think this is likely a win. The question is going to be, what does this win actually look like? What does it actually do? And as you noted at the tail end of your talk there, probably New York is not going to be just a free-for-all, as some might describe it, the Wild West. Probably unlikely to happen there in New York. So what effects would a win here actually have? And I tend to think that the court will follow what it typically does, which is write their decision to be as narrow as possible. And that may open doors for us down the road. It will hopefully open doors for us, but it will not automatically open these doors. And in the landscape of concealed carry right now, and really the right to carry a firearm concealed or openly outside the home, we have a couple different standards that are worth discussing. So you have many states and a trend towards constitutional carry. And in the constitutional carry state, depending how it's actually been written, how the law's been written, basically what they're doing is they're saying, so long as you are otherwise eligible to possess firearms, you can carry a firearm. You don't need a piece of paper from the state. You don't need to have a class that you go through, none of that. You can carry a firearm in those states. Now that comes with its own batch of troubles in constitutional carry states. One of the problems it causes for people is when they travel outside of their home state. So if you're in a state like West Virginia, for example, where West Virginia has recently become a constitutional carry state, you don't need to get a license, you don't need a permit to carry a firearm. But if you want to have recognition in other states, if you want to cross over into Virginia, for example, then you do, in fact, need to get some form of license or permit in order to carry. Another problem that typically comes up associated with that, and I'll just briefly touch on it, is the Gun-Free School Zones Act applies to many school zones, and it exempts those with a license or a permit issued by the state that they're in. But of course, it does not contemplate constitutional carry. Nonetheless, constitutional carry is one form of carry that currently exists. What New York currently is a may issue state. And that's not to say that they won't issue to anybody, but as Professor Blackman indicated, it's a very, very narrow subset of people, and they've got absolute discretion on who they issue to. And finally, we have shall issue. Pennsylvania is a shall issue state, so Pennsylvania still requires a license to carry a firearm, but it shall be issued so long as you meet the requirements. Where do I see this going? Well, with New York potentially having these laws struck down, it's going to have ramifications for a lot of the states that currently surround Pennsylvania, because Pennsylvania in the Northeast is surrounded by many of the states. I think there's 8 states that are still may issue states, and many of them right there around Pennsylvania: Delaware, New Jersey, New York, Maryland. And so one of the things that I'm hopeful is that a win at this level, although it's not going to radically change the landscape immediately, I think it will open doors for the line of reasoning that is applied in New York to start pressing the issue in some of these other highly restricted states. And that's something I certainly look forwards to. Living in this area would be to see laws start to slowly topple in these other states if we get a line of reasoning and if we get a test. Professor Blackman talked about the idea of the different tests the different circuits are using right now. One of the things that Justice Kavanaugh has urged is the text, history, and tradition test. And he's talked about this in a dissent previously. I know that there's been a lot of amicus briefs filed on this subject. But this test in particular, if it were adopted by the court, would allow them to consider not only the plain language of the different constitutional rights. But it would allow them, and when I say different constitutional rights, obviously we're talking about the Second Amendment, but interestingly enough, there are many states that have the right to keep and bear arms enshrined in their state constitutions, and often those state courts are looking to what the federal courts have done when interpreting the state right to keep and bear arms. So when I say the different constitutional provisions, the reason I say that is because this may have a tumble-down effect or a trickle-down effect, where although there are state constitutions that are in theory separate from the federal constitution, those state courts very well might adopt the line of reasoning that the United States Supreme Court addresses or adopts. The final thing I want to talk about here is the racist roots of gun control. This is something that Professor Blackman talked about very briefly, he touched on. But I think we still see, and I think if you talk to a lot of criminal defense attorneys that practice in this field, they would tell you that there are often racial effects felt from current laws and from some of these licensing laws. And I know that personally, I've seen a lot of these laws applied against people, persons of color in the inner city who might be going to and from the gun range and they have something, or they might otherwise be carrying a firearm because it's necessary for their safety, but not necessarily fit what the state has required. And so changes to the law might have a positive effect for persons of color in that respect. And I think, and I believe I'm correct in saying this, I believe that the public defenders in the state of New York have actually filed an amicus brief on this issue.
They did.
Supporting the laws being struck down, because they too see the effect that these laws have and understand how a win would give them room to fight some of these criminal charges that are having a disproportionate effect on people of color. And with that, I'll turn it back over to Oliver and Professor Blackman and Alexa.
Thank you so much. I think that's a very good perspective. People often think about concealed carry cases being like these sort of Second Amendment zealots, but very often these are not heroes. These are just people who defend themselves and their families, and they're on the wrong side of town. They live in a bad neighborhood. You call 911, they don't come in a few minutes, and they decide to take self-defense into their own hands, and then the cops find them, arrest them. It's a felony. You get deprived of various civil rights. You can be kicked out of government housing. There are lots of things that can happen to you as a consequence for bearing arms. So this is an issue that's not only trying to protect gun nut jobs like me, but also affects people who simply are just tied up with the law. So I was actually pleased to see that various public defenders in New York were willing to file a brief, and they actually took flack as if because you're a public defender, you have to be progressive top to bottom. They represent people, and people have gun offenses, and it's something that's very important. So I'll stop there. Maybe Oliver and Alexa, we can start a discussion or put some questions. I'm happy to field these however you want.
Sure. I'm still working on doling out the gift cards, so I apologize for that. I would like to just open up to anybody here who has any questions for both of these guys. They're both incredible resources, and we'll see where we can go with this.
Yeah, raise your hands. I'm happy to call on people. Okay, I see Tyler. Go ahead, Tyler.
Yeah, so I had a question about the political ramifications of this, and if that's outside of the scope of what you're talking about, feel free to let me know. But I'm wondering, because you mentioned how even if the New York law is struck down, it's going to be an incremental change. And I'm curious if you think that this is going to fall into the recesses of Supreme Court decisions and nobody's going to really pay attention, or if the activists are going to come out in full force and it's going to be a big, huge national conversation.
Right. So I think there's a couple things that can happen. One, New York will resist this as much as they can. They're going to set a very high fee to apply for a license, which will have to be repaid annually. They're going to require a lot of testing and firearm proficiency and training. And third, they're going to take forever, right? They might take 6 months, a year to process a license. I had a friend who recently got a gun in New Jersey who said it took him almost 11 months to get his license. So they're going to kick and scream. And they'll kick and scream in other ways too. Every business in New York will love to virtue signal and say, no guns allowed, because it's going to make liberals happy. So there won't be anywhere to carry. And maybe you've concealed carry before, but it's actually very hard to carry if you're in a place that doesn't permit it, right? Because you have to leave in your car, and it has to be locked in a case. And if you forget on your person, you're subject to a felony. So actually living in most parts of New York will be almost unbearable to actually carry a gun anywhere. You can carry it perhaps on the sidewalk, but you can't go inside any buildings. So again, this will be a victory for sure if New York loses, but they're not going to make it easy.
And to sort of expound on that a little bit, when we talk about the trickle down effect and how this might, the ramifications of how this might play out, I think partially it's premature to answer your question on how big a deal this decision will be, because I think in part it depends how the decision is actually written on how big a deal people make of it. The other place I see this having an effect is with what happened in Wren versus DC. It's what happened with the first New York State Rifle Pistol Club case where the laws were changed or they didn't appeal a loss. And the reason I think that this case may have that effect down the road is because if we get a positive result, it's going to signal that the court is now a court, the justices sitting on the court is a court that is going to go the pro-gun direction. And there may be positive case law coming from that. And so I think with that signaling going on, as some of these other laws and other restrictions get challenged, you're going to see people either changing their law to avoid it going up, or you're going to see people when they lose, they're not going to appeal the loss. They're going to do what DC did and open up carrying because they don't want to see it go all the way up to the high court, where the high court is going to go in what is now a more predictable direction if this case goes well. And so I think that is the other way that, although it might not have a direct effect over time, it will in fact create positive change.
Very good. Next question. Yeah, Joseph, go ahead. And then Adam next.
Yes, this is probably a question for Gilbert, but anybody can weigh in that wants to answer it. Recently, there was a shooting at the Park City Mall in Lancaster, PA, and an armed citizen intervened and, from my understanding, prevented further harm from occurring. And so far, the VA has said that they aren't going to charge the armed citizen, that he didn't break any laws by intervening in that way. But I guess the mall had a policy against carrying firearms. I guess by carrying in that situation and intervening in that situation, what did he open himself up to, either on the criminal or civil side?
I'll let Gilbert have that one.
Yeah. So certainly, and this differs state by state. There are certain states that give the effect of law to no gun zones at private businesses. And really that's what Park City Mall in Lancaster is it's private businesses. And so when we talk about no gun zones in Pennsylvania, we divide them between places that are off limits by law, schools, courthouses, post offices, places that the law specifically names, and places that are off limits by policy. And Park City Mall is off limits by policy. That means that you're not violating law when you walk in there. What is the potential for a criminal charge? Well, typically in those situations in Pennsylvania, the worst case scenario is going to be something along the lines of trespassing. And this typically comes up if they actually see you carrying the firearm after you walk past the no gun sign, they ask you to leave and you refuse to leave. Then we're talking about probably criminal trespassing. As for getting involved in the actual shooting incident, there's an old adage that I think is actually true, which is you're responsible for every bullet that leaves your gun. And in this situation, when entering that shooting, not only, and I think there's a lot to be said, and I've seen the video of it, I think there's a lot to be said for tactical concerns, right? Because you have police officers showing up to the scene, you've got an armed guy standing there in the middle with a gun. I think it's very fortunate that he didn't, good guy in this situation, as we're going to call the concealed carry intervener. I think it's very fortunate that good guy did not wind up getting shot by responding police because he put himself in a dangerous situation standing there. Nonetheless, I think he had a positive effect. He stopped what seemed to be an ongoing shooting, and I think this happens probably more than most people would like to admit in this country, where good guys with guns actually stop shootings. It's not something that typically makes major headlines on the news. In that situation, at least in Pennsylvania, self-defense and defense of others is a justification defense. And as a justification defense, as soon as you engage, as soon as you draw the firearm, as soon as you start putting rounds down range, you're certainly opening yourself up to criminal arrest. You could be arrested and you could be forced to go to trial. And the burden is on you in Pennsylvania to raise that legal defense. And of course, you're exposing yourself civilly, because you could be sued for your action. Now, fortunately, Pennsylvania does have a civil immunity statute, meaning that if you go through the criminal justice system and are found not guilty in the criminal justice system, then the civil immunity statute would prevent somebody winning damages from you for the same course of action. Now, here, it may be a little bit of a different situation if there's no criminal charges filed. Because if there's no criminal charges filed, it won't as squarely impact or trigger that civil immunity statute. And so I think that there should be concern for that armed citizen that he could wind up getting sued.
Hey, Gilbert, if I can ask a question, let's talk about Alec Baldwin for a second. This one's on my mind. You're a practicing attorney. This is like a fact pattern ripped from a criminal law exam, right? You're an actor on a set. You're handed a gun. They say cold ammo. It's not live. You think there's a shell in there that's not live. You think it's just a blank. You aim your camera at the gun, rehearsing a scene, and you go pow, and then you kill the producer, and you shoot the director, right?
Sure.
What's shake out the liability here for me? I'm fascinated by this case.
Well, again, I'm not certain which state this occurred in, so obviously I can't speak to the laws and wherever it occurred, but I can tell you I have dealt with several situations, both in Pennsylvania and Virginia where I practice, where people have accidentally discharged firearms that they either thought were empty, they believed they checked the firearm and cleared it, and they did it in the wrong order. For example, they racked the slide and then dropped the magazine. So
there's one in the chamber. Yeah.
That's right. They placed a round in the chamber and thought the gun was empty.
He dropped then
in those
racked.
Situations, almost without fail, their mindset, their belief that the gun was empty or their belief that it was clear has not mattered to the prosecution. The prosecution has moved forward with charges. We've seen everything from recklessly endangering another person in Pennsylvania, which is a misdemeanor of the second degree, to discharging a firearm into an occupied structure. Now we're talking felony charges. And so typically there are criminal charges associated with that. And sometimes I've actually had clients argue with me about why they shouldn't be facing criminal charges. And of course, I'm going to defend those people and do everything I can to help them. But I also need them. We can't walk into the courthouse just for them saying, hey, I shouldn't be in trouble for this. We need to have a realistic mindset about our defense. And so with those people, I typically start out with the rules of gun safety. And I say, you stop me when we get to one that you broke. And so we start out, treat every firearm as though it's loaded at all times.
Don't point.
Never let the muzzle cover anything you're not willing to destroy. Keep your finger off the trigger until you're ready to discharge the weapon. Know your target and what is being. And at some point, they've got to stop me and they've got to say, okay, well, I guess I broke that one, right? I did put my finger on the trigger. I did let the muzzle cover something that I didn't want to destroy.
Oh, God.
And so with all of this, I think, and I'm hearing the headlines are that a movie prop malfunction. No, a firearm.
That was a gun.
That's what happened. The gun went off. And so I would tell you, if you were a civilian, just a regular lay person, you're not a Hollywood celebrity in this situation. Yeah, absolutely. I would expect there to be criminal charges.
And by the way, Bolden's a producer also. So to the extent that there was negligence, not hiring enough people to actually monitor the weapons and surveil them, he'd probably be liable as a producer for failing to take adequate precautions to have safety, a competent safety team. Fascinating case.
And now you're into all the civil ramifications. And of course, anybody can be sued for anything. This
Wrongful
is certainly
death.
A situation where you're probably going to be sued.
Yeah, their insurance policy had about $1 million damages. That ain't gonna be enough. Okay, we got Adam and then Savannah for questions, please.
First of all, thanks both of you for being here, taking the time to speak to us. Greatly appreciate it. I have somewhat of a larger question. Over the last almost 2 years now, we've seen, especially the executive branch, bureaucratic agencies, really, what I would say, kind of take a new level of power that we've kind of never seen happen before, in the name of a public health crisis. The current administration has been using the same language, public health crisis, when it comes to gun violence. I think recently, even the director of the CDC, I'm not sure why, but also labeled gun violence a public health crisis. Just curious to hear your thoughts on what you expect the executive branch to do, or one of these bureaucratic agencies as it relates to the Second Amendment.
Sure, I'll start, and Gilbert's welcome to jump in. I do a lot of work on constitutional law, and I've done a lot of work during the COVID pandemic on various health measures. And I frankly become tired of this phrase public health. And not because I don't like public health. I do. I like health. Health is good. But when someone says this is a public health matter, what they're saying is shut up. Your opinion doesn't matter. There's no debate. I am the expert. Shut up and conform. Right. And that's why they say it's a public health crisis. Who can argue with public health? We're not talking about constitutional rights. We're not actually penumbras. This is a public health crisis. So shut up and do what I'm saying. So I'm frankly tired of that. I was doing a debate on vaccine mandates a few weeks ago, and someone actually said that the governors and states should be required to consult with scientists before they act. Right? A governor should be required to consult with the scientists for that. We have political accountability, right? Politicians make decisions; they're good or bad. People can make judgments. Now, in terms of what sort of gun control measures will these bureaucrats put forward? I think they didn't need a pandemic to do what they want to do. President Biden is very eager to restrict so-called ghost guns. In my other capacity, I actually represent a manufacturer of 3D printed gun products. That's actually a real lawyer. I just pretend I'm not. So I do a lot of work on 3D printed guns. They'll try and put them out of business. It can go many different ways. During the COVID pandemic, this is my favorite. Various cities and states banned the sale of guns. Why? Well, guns are not essential. And we don't want people online because they might crowd together and spread COVID. So they actually shut down gun stores so people wouldn't crowd. Marijuana dispensaries stayed open. Liquor stores stayed open, but not gun stores. New Jersey was perhaps the most egregious. Your governor in Pennsylvania tried to shut down gun stores. He rescinded after a couple days when he realized he was going to lose. There was a Pennsylvania Supreme Court decision that was sharply divided. And your court is not very good to gun rights, but it's sharply divided. And Governor, what's his face, Wolf, right? Wolf backed away. And Shapiro, he sued me, by the way. Shapiro sued me with my 3D gun stuff. So I have experience in your state. Gilbert, anything you want to add to that?
No, I think you're right. I certainly think that they're going to try. I totally agree with your framing of that issue, that what they're trying to say when they mention the words public health is they're saying, shut up, your opinion doesn't matter. I think that's totally why that tack is taken and why that direction is taken. I also think that it's totally unfair because it results often in essentially a request for blind adherence to whatever the authority is saying, blind adherence to whatever the sovereign is telling you to do. And I think that it's very, very dangerous. And frankly, I am surprised that, and I don't want to name names, but I've even seen people that used to be professors at Dickinson and whatnot on Facebook spreading stuff like this. Shut up and get the vaccine. You're putting everyone at risk. You need to do this. And I'm always astounded because we have it. And I'm not here to preach about the vaccine and tell you you should or you shouldn't. I think everyone needs to make their own opinion up about that. But I don't like the idea of a sovereign telling you have to do something and jamming it down your throat. And I think the same thing translates to firearms. When they get into that public health argument, they're getting ready to try to jam something down your throat. And I think it's going to take people being prepared to resist in the courts. And Professor Blackman, I read a little bit of your resume, so I'm aware of who you're representing on that. I think it takes people like that being prepared to take the fight to the courts to put a stop to it at times.
Yeah. Hey, Savannah, your hand's been up patiently for a while.
If I could just real
please.
quick.
Oh, sorry, Ann, go ahead. Yeah.
Do you see either of you see anything happening in the next, before Biden is finished with his term? Do you think anything is going to take place? Some sort of legacy before his term is up?
There's no legislation getting passed. I think that's unlikely given the current Congress. They can't even pass their Build Better, whatever the hell it's called, thing. Executive action is a different story. I think they will try to impose restrictions on homemade weapons, which could be not affect a lot of people. It could affect some people. I actually was involved in the litigation against the bump stocks. And this wasn't Biden. This was Trump. Trump decided to just ban bump stocks because he could, and almost every court upheld it. So I don't even think this is a Democrat issue. Unfortunately, both parties are pretty bad on this front.
And I would say homemade firearms and then pistol braces. That's the other one that seems to be in their sights, and something that we might see action on. I think if I knew what was going to happen, I'd be getting paid a lot more than I'm getting paid right now. But I think we've got good reason to suspect that those are both targets, and there may be executive action on them.
Okay, Savannah, go ahead.
Thank you so much. I think my question is really one of your personal opinions. And I'll kind of jump back to this situation in Lancaster that we had at Park City, where a citizen stepped in, and seemingly in that case, you'd think that that is exactly what the purpose of concealed carry is so that you have the ability to defend somebody. And so if you were talking to someone who maybe has, is in a state where they can apply for concealed carry or they are allowed to carry, and they're considering it, but they're weighing the state of things. They're weighing the fact that they want to be able to do good. They want to be able to protect themselves and those around them. But we've talked about there could potentially be criminal and civil penalties, even in the best case scenario, even when you're successful. So I'm curious whether or not you would say to that person, yes, I recommend that you use your Second Amendment right and you do what the law permits, or if you say, maybe not. I've defended a number of people in those cases, and maybe I wouldn't recommend you take that risk.
If you don't mind me taking
Please,
this
go ahead.
one
Go ahead, yes.
initially,
Yeah.
I would say that every time I talk to people who are either current gun owners, and thank you for the question, but every time I talk to people that are either current gun owners or they're contemplating becoming a gun owner, I always tell them that I've got two goals for them, and the goals go in order. Number one, stay alive. Number two, stay out of prison. And so I think we're worried about accomplishing number one first, which means a firearm is a very, very useful tool. In fact, I would argue the best tool to deal with many of these situations that are defensive in nature. And I think that the numbers are almost overwhelming when we talk, especially to talk about public health. And what they're not going to talk about is they're not going to talk about all the defensive gun uses that take place. And there's multiple studies on this, going back to the work of guys like Gary Kleck and Don Cates at the University of Florida, continuing up through people like Dr. John Lott, and even some CDC recognized studies that say, look, we don't have an exact number because a lot of these get unreported, but we're talking about at the low end, hundreds of thousands of defensive gun uses every year, up into the millions of defensive gun uses. And counter that with what we're seeing, which is maybe in the range of 40,000 gun deaths every year. And what they're not telling you about that is that number includes suicides. And although this sounds cold-hearted, it sounds crass, but if people are intent on killing themselves, I tend to believe that people have enough creativity that if they really want to, they can do it without a firearm. And so I think including that number, and even if you want to include the number, if we want to talk total gun deaths, we also need to counter that with total defensive gun uses. And for that reason, I would tell you, goal number one, stay alive. A firearm can be a very powerful tool to help you do that.
Okay. Martin, go ahead.
Hi, I was wondering that since you were discussing about how you were defending 3D printed guns, what I see as the largest federal action in gun control is still the National Firearms Act and its original establishment as a overpriced tax to get poor people not to own these weapons, and a failed legislation to ban pistols, which is why it still exists. So any discussion dealing with pistol braces and such as circumventing an NFA $200 tax stamp to make a short-barreled rifle, which was made illegal because they were going to make pistols illegal, and it's the next most concealable option. Do you see any action moving there? I mean, we've got coming on 100 years of that law being untouched.
I don't think it's going anywhere. Gilbert, what do you think?
I would also tend to say probably not going anywhere. I think, if you're pro-gun, one of the things to be thankful for is that no one has been pushing the price up because $200 was for most people, an insurmountable fund back in 1934 when the NFA was passed. And we're still talking about the same number today. And I would say, and call me a naysayer, but I would say that's a win right now. The fact that number hasn't changed.
Yeah, agreed. Any other questions? Going once? Going twice? Thank you all for your attention.
Actually, maybe I'll jump in with
Sure.
a question. Sorry about that. Just going off of the topic of the NFA, it's a topic that's near and dear to my heart. I'll be writing on it for a law review piece, kind of looking at whether common use might be used to chip away at its constitutionality. We have the latest numbers in this past year, 600,000, I think, suppressors were added to the registry in 1 year alone. So we're at a total of 2.6 million now. That's, in my book, common use, which the Second Amendment should protect. I'm just curious what your thoughts are on that kind of a challenge, perhaps, to the NFA. Certain provisions, SBRs, maybe about 800,000 out there, something like that.
It's creative. I mean, the common use test asks if a weapon's in common use, it shouldn't be banned. Then again, these are in common use subject to the NFA. So it's sort of like they're in common use. You can get NFA for it. So what's the problem?
Well, I mean, I think that the problem is still taxation. Is
Right, you
still
have to
the
pay a
problem,
fee, yeah.
and that's the devil's advocate point of view. I tend to think, and Oliver, I know we've talked privately about this. I love the argument. I think it's a good argument. Do I think it's likely to be a winning argument?
It's creative. It's creative. I like it.
It's creative, and the other thing to add to that is that there are often artificially imposed limits on what's in common use. When we talk about the Hughes Amendment and the fact that since May 19th, 1986, for civilians, new manufacture of machine guns has been outlawed. Well, now we're talking about something that's artificially imposed, because who's to say how many machine guns would be in circulation? You look at how many ARs have been sold and how many ARs have been made. I think that there's an argument that that's an artificially imposed limitation that's keeping it from being in common use.
Excellent. All right. Any other questions? Thank you all so much. I had a lot of fun. Hopefully, I'll see you all in person sometime soon. Thank you.
Likewise, thank you. And
Please.
if anyone wants to continue the conversation, feel free to reach out to me on social media, or I'm happy to share my email. It's Gilbert@Ambler Law Offices. And Oliver, feel free to disseminate that to anyone who's interested.
Awesome.
Sure.
Take care, everyone. Have a good evening.
Thank you both for being here.
Thank you, Alexa.
Yeah, thank you.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you so much.